We grow up believing the courts are referees, neutral, rational, above the fight. But lately, some have been asking whether or not they're more like players themselves. So I started wondering, if the courts are supposed to protect democracy, what happens when democracy becomes their case file? Well, we've got some data there because these referees have been busier than ever. Nearly every executive order from Trump gets challenged, sometimes paused, sometimes overturned, and sometimes revived again by the Supreme Court. Sometimes it seems like a political rally in a courtroom. MAGA Republicans argue that the court are abandoning their history as neutral referees and are becoming activists, while dissenters say that Trump is pushing the boundaries of what is democratic and trying to take as much authoritarian power as he can take. But where does the real truth lie? Obviously, anyone who has a lot of power in this space has an opinion to sell to you. Are the complaints just a partisan attempt to stroke fear for the midterms, or is Trump really breaking the court system? Hey, my name's Dylan, and my goal is to look at uncomfortable topics with lots of emotion and try to answer them as unbiased as I can. And instead, just try my best to not take a side and call misleading claims when they're misleading. A spade as a spade, you could say. I'm going to look at the data, the research, and the statistics, and try to stay as unbiased as possible to figure out the question at hand. First, we're going to look at the competing political narratives, how the courts, federal and supreme, have dealt with Trump's executive orders, and what effects this might have on democracy. So when we first talk about the narratives, the Republican narrative can be summarized as this: president equals democratic, and courts equal undemocratic. Trump was given a mandate by the people to follow his campaign promises, and that the unelected courts are impeding what the people want, thus acting as an undemocratic institution. Rarely does the Republican narrative try to talk about the legality of the actions, more so focusing on how every block to a Trump executive order is from a court appointed by Democrats. And the general Democratic political narrative can be summarized as Trump is constantly passing laws that are dangerously unconstitutional, or at minimum, unclear and need to be evaluated by the courts to figure out what's actually allowed and what isn't. And instead of focusing on how the courts are unelected and stopping the will of the president, Democrats instead focus on how the courts are a guardrail to protect democracy against Trump's increasingly authoritarian and autocratic tendencies from the likes of Putin and Xi. Now that we have these two narratives summarized, what parts of these narratives are fact and which parts are fear? Because I'll tell you, there's a lot of fear mongering going on around here, and we really need to be wary of it. It's absolutely true that Trump won the Electoral College in 2025 and won the popular vote. It's true that he campaigned on specific promises that the majority of Americans should have been aware of when voting for him. They should have been aware of what he thought about immigration, deregulation, judges, trade deficits, etc. Whether or not your average voter actually listened to what he said about his promises is unclear. It's also true that in a way, courts aren't elected. Federal judges, including the Supreme Court, are appointed, not elected. This means that their democratic accountability is indirect via Senate confirmation. Does that mean that they are undemocratic? It's tough to say because our democracy is based on people doing things on our behalf. And then the argument would be is that if you didn't like what they were doing with the Supreme Court, you could vote out the senators that approved of them, or vote out the president that appointed them for a nomination. Of course, the whole situation got emotional because basically anything that Trump did was going to be taken to court. His travel bans or his immigration orders or his spending freezes. And whenever the courts decided that they were unconstitutional, it felt really annoying that these people that you couldn't directly keep accountable were making these decisions. But it's also true that some of what Trump has done has been deemed unconstitutional by a large amount of legal scholars. For example, the 2016 travel ban, or the efforts to add a citizenship question to the census, attempts to use emergency powers to enhance the border wall, and many current executive orders, to say the least, have a tough argument for their constitutionality, at least when it comes to most scholars in the field. It's also absolutely true that the courts were intended to be guardrails, as was decided in Marbury versus Madison in the 1800s, and their goal is to block unconstitutional laws and amendments that the government might pass, even if the people decided that President, Senate, Congress was what they wanted at the time. And it's questionable whether or not Trump has authoritarian tendencies. is. This is very much up to your personal opinions. I would like to go more in depth on this in order to see what's actually truth here, but to be honest, basically everything with Trump being authoritarian can be taken either way, and it's not something where a research-based conversation can really happen. But let's look at things that absolutely are fear-mongering. Equating Trump with dictators in other countries. Whether or not you believe he's doing authoritarian things or autocratic things, comparing and saying he is just like actual autocratic leaders like Xi and Putin creates a false comparison where the situations between the US and Russia and China, even the most sinister viewing, are very different. Viewing courts as majority Democratic appointed is often oversimplifies what the judiciary actually is, while a large amount of the rulings against Trump have been from majority Democratic appointed courts. Others have come from majority Republican appointed courts. The idea here, whether or not it's followed is up to personal opinion, is that judicial reasoning doesn't have to always be partisan. And researchers actually found that the courts at least somewhat do this, as in on a case-by-case basis, regardless of political party. The strength of precedent has had a huge effect on how rulings have been made in the US over the last 100 years. It's wrong to view mandate as an immunity from checks. Claiming that Trump has a mandate from the people, sure, not wrong. He got elected, plurality of Americans wanted him, and he won the Electoral College. But that doesn't mean that he can't still do unconstitutional, unlawful things that the government needs to keep in check. This is basically just trying to get people emotional and angry at the Democratic Party for allowing these judges to mess with Trump's mandate. It's also tough to maintain the mandate argument while most polls find that Trump is -10 or less in net polling, with a disapproval rate usually in the high 50%. It's also fear-mongering to display the court as the savior of democracy. This exaggerates the role a little bit. Perhaps they could be the savior of democracy, but there's also many other checks against the president. It's just those checks aren't being used very well to check the president's power. Suggesting that the courts are the only thing standing between democracy and collapse heightens the fear factor. Now, let's look at how the courts have dealt with Donald Trump's executive orders. The majority of executive orders that Trump has passed have been challenged or had an injunction placed against them. In the first 100 days, there was around 25 injunctions, or at the rate 1 injunction every 4 days, which is extremely fast by judicial standards. When Trump signed the most executive orders in the first 100 days ever, with around 142 executive orders in 100 days, or about 3 executive orders every 2 days. Far and away surpassing FDR, who signed around 99 executive orders in 100 days. Now, let's look at the rulings on the most recent executive orders to see how the courts have dealt with Trump's executive orders. With the actions he took relating to law firms who took certain clients or employed certain attorneys he sees as adversaries, the courts have basically uniformly blocked anything against this. For example, a permanent injunction against Trump's executive order from targeting Susan Godfrey, citing violations of both the First and Fifth Amendments. Very similar rulings were dealt out to any other situation relating to law firms about these. This was obviously a constitutional issue that Trump didn't even try to deny, thank goodness, and was not allowed by the courts, because while there is at least somewhat of a plausible legal argument for basically anything, this could have led to a lot of big problems down the road if not properly blocked. Now, when it comes to federal spending and freezing of certain grants and contracts, things are less cut and dry. This relates to when the White House ordered a freeze on many federal grants, loans, and financial assistance to certain institutions and individuals because they didn't align with what the White House wanted. Overnight, the order wanted to end entire streams of grants, loans, and aid until they aligned with what the president wanted. Agencies from the Department of Education to USAID were told to shrink, reallocate, or wait for new orders. Or on many of the biggest educational institutions in the country whose funding was threatened to be stopped due to wrong ideology. The courts have blocked most of these orders, finding that they exceeded executive authority or violated statutory obligations and due process. Some actions were rescinded or paused, but the basic idea is that you can't shrink spending money once it's already been budgeted, and allocated. Next is the firing of probationary employees and restructuring agencies. A lot of this had to do with the Department of Government Efficiency when it was still around, but basically the White House attempted to fire large numbers of probationary federal employees and dismantle or reassign agencies, etc. These are employees that under most legal views are very difficult to fire, in large part due to partisan protections. But the basic Trump administration argument is that all these people weren't necessary, and thus, even with partisan protections, they were just a waste of money on the government. The courts have blocked a large amount of these orders as well, because many of the actions appear to exceed executive authority or appear to violate constitutional protections and due process. In many cases, courts demanded individual assessment of each employee rather than just getting rid of entire departments and sectors of agencies. However, the administration hasn't fully accepted many of these, and they're currently being appealed and litigated further in the court process. And of course, the big one, the one that everyone talks about, birthright citizenship, also known as protecting the meaning and value of American citizenship executive order. Stop recognizing citizenship for children born in the US unless a parent is a citizen. Multiple courts, district courts these are, issued temporary restraining orders and preliminary injunctions, calling the order blatantly unconstitutional, citing the 14th Amendment as clearly stating that people born in the US, regardless of parent citizenship, are citizens. The Ninth Circuit then declined to lift the injunction, which then left the case being brought to the Supreme Court, which later limited the ability of district courts to issue nationwide injunctions in this context without actually resolving the underlying constitutional issue of birthright citizenship. We'll talk more on it later, but they changed how injunctions are going to work in the future. But surprisingly, after doing the first read of the document, I can understand the logic behind the executive order, which says the 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not, quote, subject to the jurisdiction thereof. I am in no ways a legal scholar and totally out of my park right here. And it seems like most people who are deep into law have a different opinion according to the Supreme Court ruling in the United States v. Wong Kim Ark in 1898, where the court held that a child born in San Francisco to Chinese parents who are not US citizens was a US citizen under the 14th Amendment. So basically the idea is that Trump's asking the court to overturn a constitutional precedent that's been around for about 130 years. Now about injunctions. Obviously, there's been a lot of drama around injunctions, so this section, if I make any major mistakes, let me know in the comments and I'll pin a comment with all the corrections. But from what I've researched, this seems to be what the facts are. First, let's look at the history of injunctions. I'll give you a little hint on the history. It's all about consistent, continual growth. Starting in Osborne versus Bank of the United States, the ruling established that federal courts have equitable authority to issue injunctions against state officials who interfere with federal law, even preemptively before harm occurs, setting the beginning of what would later become injunctions. In 1895, a Supreme Court case upheld the federal government's power to seek injunctions against labor strikes and obstruct interstate commerce. This is one of the reasons that government employees are technically not allowed to go on strike. However, it's rarely enforced by the president. The Norris LaGuardia Act was not a case, but pivotal legislation limiting federal courts' authority to issue injunctions in labor disputes responding to perceived beforehand. But going back a few decades, in 1908, a huge case happened that's important for today. In the case Ex parte Young of 1908, federal courts were authorized to enjoin state officials enforcing unconstitutional laws, laying the foundation for modern constitutional injunctions. And just like many legal principles, once the first brick is laid in the precedent chain, more and more cases pile up, and they keep ballooning in size and becoming more and more powerful. The first time a large-scale injunction was used was in 1955. Before you get too annoyed when that happens, this was in Brown v. Board of Education, where the injunctions enforced desegregation. Quote, with all deliberate speed, cementing injunctions as a civil rights tool. Amarillo Production Company v. Village of Gamble in 1987 was important because it clarified that injunctions require a showing of irreparable harm, balancing the equities and public interests. And in 2008, it was updated to also include a likelihood of irreparable harm. And then we get to Trump in 2018 for Trump v. Hawaii, which upheld the Trump administration's travel ban but featured a concurrence, Thomas, questioning the legality of nationwide injunctions, arguing they exceed Article 3 limits. Thomas, still on the Supreme Court today, held an opinion that was going to be very important later on. Then in Department of Homeland Security v. New York in 2020, in this case in 2020, the court basically allowed the government to keep doing what it was doing while the litigation process continued, setting a precedent for the increased skepticism of nationwide universal injunctions. In Biden v. Nebraska, this was a nationwide injunction that basically denied the entire Biden student loan forgiveness plan. And then Trump v. Casa in 2025, the Supreme Court decision ruled that federal courts lack the authority to issue universal nationwide injunctions beyond what is necessary to give relief to the parties in suit. With the last two cases being ruled by opposite party courts, a Republican court in 2023, and before the Supreme Court, a federal court of Democratic appointees bringing the Trump nationwide injunction. But now how injunctions work is that if the people, or potentially the group, isn't stated within the actual suing case itself, they cannot be protected with a nationwide injunction. There's an obvious upward trajectory here with nationwide injunctions. They've existed at least somewhat in the modern capacity since 1908, so for about 117 years. And like we've already talked about, much of what the court is supposed to do is based upon precedent. Just like in politics, most things can be argued as correct or wrong by reasonable people. That's why courts have placed a heavy emphasis on history and precedent over the last several decades, as the judicial branch has gotten stronger. One of the gripes many people have over the modern Supreme Court is that in many recent cases, it has argued against history and precedent. For example, they argue Roe v. Wade, which regardless of your opinions on abortion, was the precedent in history for about 5 decades, erased in one case. This is why many argue it's dangerous to have many sweeping social changes and other things tied to the court itself, instead of Congress and the presidency. Okay, you got through a whole bunch of information, so now let me reward you with your favorite part of this video. What's the effect on democracy? Is it actually on the line? Is it bending under pressure? Is this just all big low and nothing? Let's look at both sides. With this current ruling, many conservatives argue that the court is pulling back and returning to a state of judicial restraint, basically saying the court is refusing to police every political fight, remind everyone that the courts are just there to stay and strike down the obviously unconstitutional stuff. Everything else, leave up to Congress and the president. The idea is that since these courts are unelected, in a way, with them taking their hands off a little more, the system is more democratic as a whole. And the downside that many Democratic supporters like to point out is that restraint, especially in an era like this with a potentially autocratic president, could weaken a tool that one of the other branches of government had in order to check the power of the president. If the courts hesitate to stop a president in fear of pushing too far, what's left to stop him, especially in a dysfunctional Congress that we currently have? Many argue judicial restraint is less like humility and more like waving a white flag. And that's not the theoretical risk here, whether or not you think those claims are true. Democracy usually isn't overthrown violently. It's one broken norm at a time. Much of what keeps a government going isn't even written. It's tradition. Like how the Senate's pro tempore role is traditionally given to the longest serving member of the majority party. Not because the law says so, but because it's tradition. And a huge part of the Senate culture and stability comes from this. And the idea is that if you break enough of these political traditions, you get chaos that no constitution can fix. You've seen similar things like this happen in Hungary, which, while still a democracy, has seen a decrease in how democratic its institutions are. You've got Russia, which used to be a democracy before it was overtaken, and the decline of democracy in Poland, although that seems to be reversing somewhat now. Basically, whether or not you think the Democratic interpretation is correct, the idea of having a dysfunctional Congress and a more weakened judicial branch means that if the executive is held by a president who wants as much authoritarian, autocratic power as possible, the system is at a greater risk than normal. However, it's important to know that it's not like courts completely got rid of injunctions and that they're gone forever. They just have a more specific case-by-case basis instead of the universal nationwide injunctions that we're used to. But by narrowing their reach, they left more room for politics and presidents who might want to stretch the rules. So democracy isn't broken, but there are cracks in the wall, and whether or not you think the executive wants to break open the wall is up to personal opinion. So is Trump breaking the court system? Maybe. Of course, it's politics, and how are you really meant to have an opinion without being biased? But breaking might just not be the right word. But there's evidence that the system might be getting strained. How Trump treated the law firms was not a good look, to say the least. But the court system was able to do the right thing in the end. And many of the orders that Trump has signed in have been controversial legally. And that's just a fact of the matter. And with this in mind, the Supreme Court ruling in a more judicially restrained way and reducing the amount of power that the judicial system has may leave a path open for an undemocratic, autocratic, authoritarian executive to hurt democratic rights. But the court has still not gotten rid of injunctions, and they can still be used in order to protect against unconstitutional situations. There's a lot going on in politics now. One is a seemingly radically increasing amount of political violence. And after the terrible event that happened to Charlie Kirk a little while back, MAGA commentators asked the question, is the political left to blame for political violence? And you know what? The research has a claim that you might not be expecting. You can check that video out right here. And don't forget to study Supreme Court history, try not to fearmonger, and think controversy. I'll catch you over in this video right here.